Good afternoon. I'm Mark Radoff, attorney with California Indian Legal Services, and this is one in a series of webinars on the Indian Child Welfare Act. The topic for this webinar is, and my contact information is on the screen, the topic for this webinar is the two cases that came before the California State Supreme Court last year in 2016, addressing the ICWA active efforts, specifically enrollment in a tribe, the efforts to assist a parent and child, and the forfeiture doctrine. The California Supreme Court has only taken 3 cases in 38 years, so these were significant statistically. The 2 of those cases were decided and briefed and argued on the same day last year. Our program, CLS, filed and argued amicus briefs in those 2 cases, Abbigail A and Isaiah W. Briefly, Abbigail A was a case involving the social services agency's obligation to assist in enrollment of Indian children in a tribe under a rule of court that was the subject of the case. And then Isaiah W. addressed how long is too long to appeal an ICWA violation and whether or not it's been forfeited. Under the Indian Child Welfare Act, which was originally passed by federal law in 1978, the state Supreme Court has only taken these 3 cases. WB was 4 years ago, 5 years ago now. That was, the citation is on the screen, 55 Cal 4th, page 30 in 2012. The issue in WB was whether or not the Indian Child Welfare Act applied to the to delinquency cases, to 602 cases specifically. And after that case, the court did decide to limit the application of ICWA and delinquency cases. We also argued that case as an amicus and filed briefs. The other cases, the 2 that came from last year, are cited on the screen. And as I mentioned, the rule of court requiring enrollment assistance was at issue in Abbigail A, and then Isaiah W. was the second case that talked about a parent who waits until the last set of hearings to appeal and does not file an appeal earlier in the case proceedings. But to back up a bit, because Abbigail A involved a type of active efforts, and in fact they were called active efforts in the rule, you have to ask what are efforts. And both California law and federal law require a certain amount of effort to be made to reunify a family and deliver services, which are 2 different things. There's also maintenance of a family, which is when a child is not removed. So that it makes a difference depending on what the plan is and where the case is in terms of its timetable. The legal standards are different, and even though California requires reasonable efforts and federal law requires active efforts, there's been some confusion about what that means, whether they're equal or not. There was some older case law in California that said that that reasonable efforts and active efforts are the same. They're essentially undifferentiated. That is not the case, at least under the new federal regulations and under the state law that incorporated the federal law. Reasonable efforts are when a child's been removed from a parent or parents or an Indian custodian or a guardian. When a child's been removed, 361.7 requires the court to determine whether the agency made reasonable efforts to prevent or eliminate the need for removal, and also the conditions that led to the removal. So there's some kind of underlying circumstance that needs to be corrected, and the standard, the metric, the criteria that the court assesses is reasonable efforts. So it's not just a generic term. It's a legally defined term. absent a reasonable effort, the agency's removal is improper, meaning the kids have to go back, kid or kids have to go back to their parents' custody. The finding is made both as to the type of services, so look at the specific services being given, whether they fit whether it's reasonable given the situation of the family, and also the circumstances, under the circumstances. So it applies in different fashions. Compare that to active efforts. Active efforts, by contrast, are what is imposed by 25 U.S.C., that's the United States Code, Section 1912, as part of the remedial efforts and rehabilitative measures that apply when an Indian child is involved in a removal case. So this is another standard. It's a higher standard that applies when it's with an Indian child, which is defined in the federal law. Active efforts, if you don't remember anything else, it's higher than reasonable efforts. And active efforts have also been incorporated into California state law in the section cited on the screen, 361.7. So what's the difference? Active efforts versus reasonable efforts. For a while there really was substantial confusion about this. Recently, though, the federal regulations, which were issued by the Bureau of Indian Affairs to interpret the federal ICWA, has a list of 11 items that are not they're not exhaustive, so they are exemplars, but they're not the only things that can be active efforts. And these are items and actions above and beyond reasonable efforts. So reasonable efforts still applies. On top of that, you add active efforts, so there's more efforts. And the probably the reason for the confusion was that these were somewhat loose standards. There wasn't any exact criteria. This alleviates that issue. But to confuse matters a little bit, there are guidelines that interpret the regulations. Those also have guidance. They're not given the same force and effect as federal law, but you're going to have to look at all three on the federal side: the federal statute, the regulations, and the guidelines. And then on the state side, we look at the California statute, the legislation, as well as the rules of court. And again, the rule of court was the question in Abigail A. The efforts specified, some of the efforts specified in the federal regulation are listed on the screen. They include making comprehensive assessments of the family, identifying appropriate services, and that would be culturally appropriate services, inviting the tribe to participate and be part of the plan, the drafting and implementation, the culturally appropriate services, keeping siblings together. That's a requirement under state law, but this is also a higher requirement to keep Indian children together, and identifying community resources, including housing, transportation, mental health, peer support services, or alternative delivery systems if the original plan doesn't work. They should be customized, should be tailored to the particular family and their circumstance. And think of it like a medical procedure. It's targeted to fix the problem. It's not some generic cookie cutter solution. So what happened in Abigail A? In Abigail A, the issue was centered around membership. Membership was the threshold issue. Without membership, the ICWA didn't apply and couldn't apply. So because the child is not deemed to either be eligible or a member, that's the definitional standard. And the rule includes eligibility. So if you have a child who is not a member, and that's not always the case, for example, you'll have an infant might be born without being a member because they're a newborn. Some tribes have grandfathered in children or given a grace period for the first 180 days. That's not the general rule. The general rule is somebody has to apply for membership or enrollment. They go by there's different terminology. But the issue in Abigail A was whether social services would assist in enrolling the child or assist in the enrollment application when the father could not himself get enrolled automatically. He was not a member. He may have been eligible, but he was not a member of the tribe. So The facts, though, in that case were somewhat difficult and problematic because both the children, Abigail and Justin A., were placed with their grandmother, their maternal grandmother, and that would have been a preferred placement. That would have been what the act required, the federal act and the state law. And the agency was then ordered to make active efforts to enroll them in the Cherokee Nation. The tribe said that the children were eligible, but the father was not enrolled, and so the tribe said that the children could not, it was a conditional eligibility. The father had to first get enrolled before the children could become a member. But neither the father nor the children could get the documents to Cherokee tribe to move the process forward. Those are held and controlled by the agency. So that's where we hit the issue. Rule of Court 5.482C is the rule that was challenged, or there were two rules that were challenged, but the first of the rules was challenged because it required the agency to use active efforts to assist minors who are eligible but not yet Indian children. And in that scenario, the children were putatively members, they were potentially members, but they had not become members, and they would not be without some form of help, and the social services was directed to give that assistance. The court in Sacramento, the juvenile court, applied the law of ICWA during that process, and the agency pushed back and challenged the validity of the rule because in their mind the court was applying ICWA before the children had been found to be Indian children. Part of the issue, and I think I have a slide on this coming up, is active efforts was the terminology used. The agency had to use active efforts, and that terminology is what is used to give services once an Indian child is found to be an Indian child. So the active efforts probably confused the matter, and I'll talk about that in a little bit. The other rule, 5.484C, so we have 5.482C and 5.484C. The second rule addressed the level and type of services, the efforts that had to be made to Indian children after there's a finding that it's an Indian Child Welfare Act case. And it included assistance in obtaining membership or enrollment applications. There's all types of services that are obligations that a parent or the agency might have. The agency steps into the shoes of the parent, so if the child needs medical care, needs to get school assistance or enroll in some program, an IEP, all those things would be specialized health care, mental health insurance, driver's education classes, things that normally a parent would do, the agency is supposed to do, and this rule says that includes assistance in obtaining membership. So that's what the agency has undertaken. There was a time confusion because the court upheld, and I don't know if it was confusion, but it was the basis upon which the court decided. The Supreme Court upheld one rule and not the second. So 5.482 was struck down because it applied the act before an ICWA finding had been made, before a child was found to be an Indian child. I think it might have been avoided if the term active efforts had not been used. They'd been called something else, anything else, just make extraordinary efforts or make reasonable assistance or give some kind of facilitate measures or something, but it said active efforts, and because active efforts is the terminology that is used after an Indian child has been found as a finding of the court, active efforts then was a confusing term because it's also the legal standard for the type of services that have to be offered to reunify a family. So just as an aside, that issue may have partly been there because of the terminology. 5.484C was upheld because it was part of the duties, specific duties the agency was obliged to give to dependent children. Why is it important? Well, definitions are significant in all statutes and all cases, and specifically in this context, the ICWA defines, it's a definition for an Indian child, to be an unmarried child under 18 who is either a member of an Indian tribe or eligible for membership. And the second part has two parts, eligible and a biological child of a member. So in a sense, it can become circular logic, because without getting the assistance from the agency to become a member, the agency can avail itself to a lower standard. So and that's not to suggest that they did or would or even should do this, but that is a problem. The agency doesn't advance the ball down the field. The children aren't Indian children by definition, and then the lower standard applies. Again, the case in Abbigail A, the court said, let's just apply it anyway, and that was what was challenged by the social services. As I just mentioned, it becomes a self-fulfilling prophecy, because without assistance in membership, there's no eligibility, and therefore the act doesn't apply. The control of documents is significant, because many tribes require the original Social Security card or birth certificates, and the parent can't get those. Only the agency can get those during the time when the case is under dependency jurisdiction. And absent some kind of order compelling the agency to give those or to turn those over to the parent, that's something that a parent can't control. And then in Abbigail A, the father had his own set of issues, because he had to get enrolled himself. If ICWA does apply, what happens? So in the prior slide, if it doesn't apply, reasonable efforts would be the standard. If it does apply, there's a whole host of things that get plugged into the case, including Indian placement preferences in Indian home or tribally designated home. Tribes can license foster homes. There's a sequence in the code that specifies who are the preferred placements for Indian children, and those have to be followed unless there's good cause. That's one item. Another item that would apply if there's an ICWA finding is that the children can only be removed and placed in foster care or parental rights terminated, but at 2 different times with the testimony of an expert witness, a qualified expert. And that is a standard that is not found in ordinary dependency cases. The tribe can intervene, participate, even transfer the case to a tribal jurisdiction. And then there's a higher standard of efforts, the active efforts, not reasonable efforts. And even there's also a higher burden of proof for the findings at the various stages. In Abbigail A, the tribe sent a letter which was a factor, because the tribe wrote that the children were eligible, but it was not, the tribe itself was not empowered to intervene in the case unless the children or eligible parent received membership. I think it was just one parent, not parents. So arguably this is limited to a narrow set of circumstances while the parent's application is pending. The expert witness went beyond the scope of what the expert was supposed to testify to, and the expert witness overstated the facts, or at least went outside of the facts that were beyond the call of his or her question, and said that there's no way the father could ever get enrolled. His mother, I believe, was deceased, and that was not accurate under their ordinance, but that put the expert and the court in the position of interpreting tribal law, which was a separate problem, but that certainly weighed in on the appellate level. Without that letter, the testimony and testimony of the expert, the result might have been different. The lower court, the appellate court, treated the rules identically. They looked at 5.482 and 5.484 as if they were identical rules. But again, the 5.482 applied while the application was pending, and the active efforts, or the efforts, whatever was required, was during the process period, whereas 5.484C required steps to secure tribal membership and active efforts after an ICWA finding had been made, as an attempt to use all the available resources, extended family, social services, and everything to prevent the breakup of the Indian family. So if the father had already been enrolled, but the child was not, and the application was pending, that would have met the definition of the exact definition in the code, and that would this second rule of court would have required the agency to assist, along with all the other things they're supposed to do as part of the services. Bottom line was the California Supreme Court upheld one rule and invalidated the other. This is repeating what I just said, but 5.482 went beyond the statute according to the Supreme Court. And it didn't just fill in a gray area like rules of court do, and it was premature. It was cart before the horse. It was making a finding before the actual ICWA finding had been made. It was, so that was where the agency took issue with it. And the 5.484 though is just one in a component of many of active efforts, and also a component of reasonable efforts. I note that there is something in California called the Foster Care Bill of Rights, which is a huge list of obligations the agency needs to make to all children in foster care. And I believe there's an analogous one for delinquent children as well. And in there are obligations to allow children to participate in cultural and personal enrichment activities, extracurricular activities. It can and should include access to tribal culture, membership benefits, scholarships, healthcare, tribal governance. Those are a separate argument. We argued this in the amicus. The Supreme Court did not make a ruling one way or the other. It was not the basis of the court's decision. So that's not really, there's not any clarity on that from this case, but that is still a separate basis if you're looking at the rights of foster children to participate in all kinds of activities, including cultural activities. There's other rights to maintain sibling relationships, and I can't really paraphrase the whole Foster Care Bill of Rights, but it is in the code, and it's worth looking at. Beware of the two parts in the embedded two-part test, because ICWA applies if two conditions apply. One, as I've mentioned, the child is already a member. But number two, more problematically, is the child has to be eligible for membership and the biological child of a member. So a literal reading of this would mean that a child who is eligible but not the bio child of a member, it knocks it out of the test. So this can and may be read as a two-pronged test. That's that's the language of the federal law. So eligibility alone may not be enough. In the past, when a tribe said a child was eligible for membership, that was all that it took. That was the end of the question, end of the inquiry. But the court asked, although it didn't decide on this basis, what would happen if the parent is not a member or not eligible. That could arguably knock out the applicability of the test. California has a distinction between presumed and alleged fathers, as well as biological fathers. Presumed fathers are fathers who have held themselves out as a parent, taken a child into their home, not necessarily with a physical or biological relationship, and California gives the highest standing to presumed fathers. Federal law and the state law under ICWA applies to bio-fathers, biological fathers. Alleged fathers come into play when it's an allegation. The mother says, I believe that's the father, but there hasn't been any definitive testing or finding or order or ruling or anything, or signing off on a birth certificate, anything to substantiate or corroborate that. Just keep in mind this was not part of the case, but I'm mentioning it because California has treated presumed bio and alleged fathers differently, and the federal law under ICWA applies to biological fathers. So the tribe can come in, and if there's a paternity test and it's a biological father, the tribe can basically say that overrides the state priority for presumed fathers. The second case had to do with delay in appeal. Isaiah W. was where the mother waited. She deferred appealing an ICWA issue, as a notice issue, till the end of the case. The court denied, at the appellate court, denied the appeal because of the forfeiture doctrine. In essence, they said that she just waited too long. The delay cuts off or forfeits her right. So what is this forfeiture doctrine? Stepping back a moment, California has two kinds of juvenile cases, dependency and delinquency cases. Both cases are found in the Welfare and Institutions Code. Section 300 is for dependents, 600 for delinquents. Dependent minors are child welfare cases. They arise out of the conduct or mistreatment, abuse, neglect of caretakers, guardians, or parents, or Indian custodians, or someone else, as opposed to delinquency cases, which are based on wrongful conduct by the minors themselves, criminal or wrongful conduct. Forfeit means to lose. Forfeit means to give up. And so the forfeiture is to just to lose that right to appeal. The other thing to remember, the dependency cases have at least 5 distinct stages: detention, jurisdiction, disposition, review hearings, and permanent plans. Detention is the removal, usually the initial hearing where there's been some kind of physical replacement of a child, taking somehow a detention, I guess is really the best way to put it. The jurisdiction is where the court has to find whether a child is described in Section 300A through J. There's a number of criteria whether the child fits within the description, and then that gives the court jurisdiction to make decisions. Disposition is analogous to a sentencing. It's the case plan where the court comes up with a criteria for reunifying the parent with the child or maintaining the child. Family maintenance is where there's not a physical removal, but the court can still have a case plan or service plan. Then the review hearings will check in, basically like a report card on each of the parents' progress, if there's 2 parents, and see when the likely date of return is or the likely date of dismissal. And then depending on what happens in the review hearings, move the case towards permanency, which is either going to be a permanent plan of adoption or foster care, guardianship, or another permanent plan, which is, we're not calling it APLA anymore, but another permanent plan, living arrangement, I think was what it was going by, but it's some kind of permanency. It's the plan to either fish or cut bait, put the child or children back with their family, or find another permanent home. That permanent plan can just be to dismiss and to return and go back to normal, or it can be to find some kind of permanent placement for a child, hopefully with someone they know, a family member, or it can be somebody, a foster parent, if it's been a long-term foster relationship. But the point is, not all of these 5 hearings and their variations are final. Only the permanency planning hearing, which is a 366.26 hearing, will be final. But also disposition is considered to be a final hearing for appeal purposes. It can be appealed. And that's exactly what happened in Isaiah W. Isaiah W., the mother did not appeal after disposition. So this is a procedural, technical issue, but it has real-life consequences because not every order can be appealed to the higher level from the trial court. The alternative procedure is to do a writ, but most times, if it's going to be an appeal, it's going to be after the whole case is over at the end, when all is said and done. But the fact that disposition is considered as a final hearing is it's treated as if the game is over for those purposes. So that is what caused Isaiah W. Typically, appeals come in most civil cases at the very, very end of a case, unless it's some kind of interlocutory or interim appeal. So why is this important in an ICWA case? Well, the ICWA doesn't have any kind of deadline like this. It imposes a continuing duty on the agency and the court to apply the act all the way through. And so if there's an ICWA noncompliance issue, including notice and inquiry, then there's still an obligation to comply. Still, a party, parent in this case, but it could be the minor, it could even be a tribe if the tribe had in some way been involved, should object and identify the error on the record, and then the court can either correct it or ignore it or rule against the party, but at least the objection is noted and preserved for the record. The forfeiture rule, though, says if you do not take an appeal, it's forfeited, it's waived. Isaiah W., here's the lower court citation, 2014, so it took a couple years to make its way up. 175 Cal Reporter 3rd, 754. That's the unofficial reporter. I don't have the official site. You could probably get it through FindLaw or Google or some other way. As I had said, this is one of 2 cases that was heard by last year's Supreme Court, and they were argued on the same day. And there's only been 3 cases all total in the 38 years that ICWA's been around, so that it was significant. The issue, the factual issue in Isaiah W. was the mother had a positive drug test, positive toxicology report for marijuana, which is unrelated to the notice issue, but that was the basis for removal. And when she was interviewed by the agency, and I'm using agency generically for social services, DPSS, Social Health and Human Services, CPS, the shorthand, I'll just call them the agency. She said she had a belief she might be Blackfoot or Cherokee. No action was taken to follow up on that, and we passed through detention, passed through jurisdiction, and then the court did not make a finding one way or the other at disposition. Why would notice be important? Well, if there's no notice given to the tribe, they can't participate in those early stages, including development of the service plan, including the identification of placements. And notice is probably the key component. It's the gateway for the tribe to participate. California, though, has adopted its own version of the ICWA, and it imposes even stricter requirements in ICWA cases. And there is a rule in the federal law that says if there's 2 standards, one weaker, one stronger, follow the stronger of the 2. So where there's an inconsistency between California federal law, you follow the stronger of the 2 laws. Basically it's a floor, not a ceiling. The federal preemption is federal preemption is where federal law trumps state law, and it means that if state law says something different, federal law controls. But in this case, federal law said follow whichever is the stronger of the 2. The final judgment, as I said before, is usually the final judgment. It's the end of the road. The case is over. But now we have 2 final judgments for purposes of appeal in this case, because California Rule of Court and the statute, Section 395 in the Welfare Institutions Code, Rule of Court 8.406, A1, have a deadline, and they require an appeal to be filed, a notice of an appeal to be filed, no later than 60 days after a final judgment. So that's the final judgment, 60 days after. But the forfeiture rule is, the forfeiture doctrine is, it's given up if you don't file an appeal or notice of appeal. And disposition was treated as a final judgment. So anything past the 60 days, 61 days, is untimely. The making an objection on the record is usually a prerequisite to making perfecting the appeal, because if you don't make an objection, there's nothing for the court to review. The ordinary sequence would be someone objects, the court says I overrule it, or they don't rule, but the objection is made specifically as to what did or didn't happen, and none of that occurred in Isaiah W. Mother didn't raise the issue until all the way on the back end of the case when she was at the 366.26 hearing. So think of it this way, it's not perfect analogy, but post-disposition can be seen like overtime, because even though it's final for purposes of appeal, there's still a lot to be played, and the resolution was not final until permanency. And because the court and agency owe a continuing and affirmative duty to inquire whether a child is an Indian child, so they make the inquiry once, they don't find anything, they later get other information. They have to keep inquiring and give notice if they find out that new facts or something that would lead to the belief that this is an Indian child and the act applies. The court has to keep making this inquiry after disposition. So even though there was an appeal possible at disposition, that didn't excuse the court and the agency from continuing to inquire. And a parent can get it wrong. They might identify the wrong tribe. They might do something. They might not want the tribe involved. There could be any number of reasons why there's a false lead, or there's no lead, or no information. The notice allows a tribe to intervene early and transfer, and their position is weakened if they come in at a later stage. It used to be the rule that the more advanced a stage the case was at, that the less likely the court would be to transfer it to tribal court, because the advanced stage requires some kind of finding of good cause to deny that, and advanced stage was considered a basis for good cause. Also, parents objecting can also be good cause. What can't be good cause is the adequacy of the tribal court. But because cases are divided into stages, there's usually a later stage in each part of the process, the 5 sequences, 5 steps that I had outlined earlier. The membership of a child is affected. The delay can not necessarily preclude, but it can certainly defer the decision to a point where it's not going to be possible to complete the membership application in the 12 months or 18 months, at the latest 24 months that the case should be going. So the later it happens, the more difficult it might be to complete or perfect that process. The membership, though, under both the federal law and state law, is a decision that is made by the tribe, not the court, not social services, not the parent. So under Cal-ICWA, which is the California interpretation or incorporation of the federal law, the membership decision of the tribe is conclusive under this section, 224.3E1. So the court cannot substitute its judgment or disregard the tribe's decision. It's the tribe that decides its own members. The timeliness of the appeal also was based on whether there was reason to know. This was a minor child. This minor was an Indian child. The mother's counsel, mother argued that even the suggestion of Indian ancestry triggers the notice provisions. I don't know if I would go that far. There is case law to support that. The hint or the wisp or the just the teeniest tiniest suggestion is probably enough to make inquiry, but it may not be enough to make the court give full blown notice. But attorneys can disagree on that point, and that's not the basis. That was not part of this decision. But either way, without notice, the substantive provisions cannot apply. So notice is essentially the gateway to applying the act. And if a mother doesn't give adequate, accurate information, or if she just waives it by, for whatever reason, in whatever way, the effect is it's a tribal waiver, because the tribe doesn't know that it can apply or intervene or participate. The delay is a denial of justice for the tribe. It's just, even though it's not intended, or it might be intended, that's the effect. Here, the mother waited 1 year and 3 months to appeal the lack of notice. Again, that impacted the tribe's substantive rights. And because the hearings serve different functions, the disposition adopted the reunification plan. The tribe or tribes did not have any role in that. They would not, and were not allowed to offer any kind of cultural services or involve the extended family or the tribe's expertise in this plan, and nor were they able to identify any placement with a Indian family or preferred placement. The failure to notify, simply put, just forecloses their involvement on that level. The denial of the application is equivalent to sticking your head in the sand. It just doesn't work. If you don't apply, if you don't know, you don't tell them, it's not going to advance the application of ICWA. Also, the waiting in notifying the tribe increases the bonding with the foster parents many times. So even though the court went out of its way to state that the parent's waiver of the right to appeal or application of the act did not mean the tribe was waiving its rights or the tribe lost any rights, that's the practical effect, because the delay in notification means that none of the things that would ordinarily happen in the regular course of events for an ICWA case simply couldn't occur. California had a split of authority on how to fix this situation before Isaiah W. Pedro N. had, and that was it's an older case, 95, almost over 20 years ago, and the citation's up there. The court there held that the mother who identified a Mono Indian tribe and then at detention and then North Fork at disposition, so the two different tribes, was foreclosed from raising ICWA compliance 2 years later at the termination of parental rights hearing. So you waited that long, you waived that right, you forfeited it. Dwayne P., a later case, said that the parental inaction did not excuse the juvenile court from giving notice or making inquiry. There's no time limit. That's the important part. They don't have a citation. You'd have to track down Dwayne P., but the difference is Dwayne P. said there's no time limit on exercising ICWA compliance. Pedro N. had an expiration date, a hard stop on expiration, and it was too late. Dwayne P. did not. The reasoning behind this is that the court can still act while there's something to do. You can't go back and say, oh, you should have done this, you could have done this, you would have done that. The court is in no position to correct anything if it's not called to the court's attention. So you can't sit on your rights, you can't hide them, hide the ball. Those are problems that can be fixed by notifying the court, letting the court know, and giving the court a chance to fix them. Keep in mind, dependency cases are not different than the regular rules of civil procedure, unless it's specified. So they're not exempt from the appeal procedural rules. INRI SB is a citation where you have to make an objection if you could have made an objection. That's where the forfeiture comes into play. You can't challenge something you did not object. I've probably said this several times, but that you have to make that objection, and you have to note it for the record, and the court has to have a chance to respond. The other side has to have a chance, and then you can take it up to the next level to a different court. Isaiah W. argued that the dependency cases are exempt from this. I believe it was the mother was arguing this, and that forfeiture could be excused. There's another line of cases where if it's an important legal issue, then the forfeiture rule can be excused. But all this, the backdrop of this is that California is still bound by federal law, which preempts state law. It trumps the state law, and it overrides the state law. And preemption means that where there's no expiration date in the federal law, that is an argument to disallow the forfeiture through the state law. So the most basic way to put it is federal law has no expiration date for compliance. State law, general procedure does, but because the general rule is that an appeal can be forfeited, the specific rule in this particular case should not allow that. That's how the court ruled in Isaiah W. And and one of the justices asked about this and made the distinction between the general rule and cases like this, where, and I'll get to it, there's a separate remedy for invalidation. The California Social Services and tribes are looking at the same facts from a different vantage point, a 6 and a 9. They are looking at it as if the tribes are seeing it as a continuing sequence of obligations, and whereas at least in Isaiah W was looked at as a undifferentiated from the regular procedural rules. The federal and state law allow for, and also federal and state, it's federal law, but California's adopted it. They allow for invalidation. It's an after-the-fact procedure peculiar to ICWA, where you can undo a case. There was a federal Supreme Court case, the Mississippi Band of Choctaw Indians versus Holyfield. That case was an adoption, not close to these facts here, but it was well after the fact. And so because there's an invalidation allowed later, that in effect is an appeal. It's called by, it goes by a different name, but it allows a parent or tribe to undo a court order for noncompliance. Keep in mind, it's not every type of ICWA noncompliance, but notice is one. And in this case, there would have been the right to invalidate, assuming that the Blackfoot and other tribe, I'm not remember the other tribe's name, were established to be the mother's tribe. So you get to the same spot, and you basically get an appeal, and it gets sent back. It gets remanded to the court to comply. So it has to go up to a new court that's competent to oversee the appeal of these decisions, which is probably going to be the Court of Appeals. So what I'm saying is, you get to the same exact spot through invalidation. And invalidation, it's just like a rooster. It just keeps crowing all through the case. It never goes away. So there's not going to be the same stop that you see under the 60-day rule for appeals. After Isaiah W, the court seemed concerned about the possibility or potential for a blanket waiver by a parent that affected the tribes, and the tribes, the court didn't really address it. The tribe could be adverse to the parent, and there could be a reason that the parent doesn't want the tribe involved. But the invalidation, if the tribe comes in and finds out at some point, it can basically go back and you do a do-over, which is hard on everyone. It's a relitigation of the facts of the procedure, and children are older, and that is a far less appealing alternative. But the forfeiture rule is still valid for non-ICWA cases. It's not. This court ruling did not undo it. It just applied it differently in ICWA cases, and specifically with respect to the notice violation. Again, just to reiterate, the best practice is to object early and often and notify the tribes independent of the county. Just make sure that the tribe is involved and that there is a notification. So I'm going to go back up and put my contact information on the screen again, scrolling up to the top, that's the end. This is me, this is my contact information, and we'd like to thank you for listening. We have other presentations on the webinar about the ICWA regulations specifically, which is a more detailed discussion of the new rules that came into play last December 2016. So with that, I would thank you, and we would adjourn.